Hello, hello.
Hey guys, how you doing?
We're out here thriving. It's 11 a.m.
It's been a week.
Sure has been. So, David, you're the founder of Cowrie, which is a crypto native advisory firm specializing in domestic tax compliance and entity structuring. And we're one of the drafters of the DUNA, which is a new legal entity structure that many of the DAOs are beginning to adopt. So, I guess as I understand it, the DUNA, which is a decentralized unincorporated nonprofit association, was kind of built off of the unincorporated nonprofit association. Can you just give us a quick overview of the history of UNAs and then what specifically DUNAs add to it for decentralized organizations?
Yeah, American law is built on the common law. We're all kind of generally familiar with the way that process works. We kind of inherited a lot of our laws from England. We adopted them, and entity formation was something that happened in a historical context, right? There wasn't always a corporation. There was an evolution from kind of a feudal monarchy in England to the introduction of commerce, exploration. Victorian England started the very first, corporation, which, at the time was more of a business license than it even was in any form. People in the kingdom were able to actually start doing business in the areas where they're able to get incorporated. And that involved over time. And I mean, we're going to fast forward through, hundreds of years of history, and just, over time, there became the need for workers to establish, for owners to establish, for partners to establish. And so there's two really basic forms of, corporate law that begin in existence. There's corporations, there's partnerships, and then within that context, there's also trusts and insurance companies were always kind of set to a side because that's just how it was done. And so within the history of that, modern entity formation, modern entity forms have, over the past 100 years, 60 years, have really evolved into a lot of hybrid entities. The LLC carries a lot of the characteristics of a partnership, but it has the corporate treatment of a corporation. You don't incorporate it, but in more ways acts like a corporation than it does a general partnership in most cases. Extensions of limited partnerships have extended what the original general partnership did. And within that evolution, there was an unincorporated nonprofit entity. And so historically, that was treated the same as a general partnership under the law. It was just the nonprofit version. It was formed for some other purpose than the people who were forming it to split the profits directly amongst themselves. Various states, particularly California, led the way on it, but various states, through their statutory adoption, through their courts, changed some of the protections, some of the treatment around what it was to be an unincorporated nonprofit association. In the early 90s, there was an effort from the Uniform Acts Commission to make that the more uniform standard. And it was more or less successful, generally successful. About half the states have adopted some version of the Uniform Act, or like California, built something very similar to it that provides protections for unincorporated nonprofit associations. What those protections are liability protections for matters of tort and contract, which is more or less is essentially what you would expect to want to have liability protections for. It also allows the entities to be sued or be sued in their own names, allows them to hold real property, basically clears up all the ambiguity around when two or more people do something, what is it that they're doing? In the case of the UNA generally and DAOs and projects that were looking for a home in the United States, a lot of the corporate entity forms just didn't really fit very well. You wouldn't want to put a DAO, a membership association, inside of a corporation. A board of directors would be somewhat an anathema to the process of decentralization. You certainly have the ability to make member-only LLCs, but the question around that would be what those interactions would be, who's ultimately in charge. And so the UNA presented a historical background that was a little bit better of a fit because, one, there just hadn't been very many of them, and the statutory history existed intentionally to make informal organizations have a home. So if you were looking at a church association or a funding drive, and you hadn't done an official formation of an entity form, you could end up being an UNA through default or choosing to be one without having to have done that much. Your coming together as a group is what made you a partnership, or that association is what made you exist. And so the law really struggles with when two or more people do something, when a group of people do something, who's ultimately responsible. And so the UNA is kind of a protection for what should happen when two or more people do something and they're not forming a general partnership. One of the areas I think a lot of people are confused about, you'll see it in a lot of the DAOs, they'll write into like their bylaws, we intentionally are not forming as a general partnership. And your intent to form a general partnership isn't what drives whether you are or not. It's the relationship you have with each other. So by looking at the unincorporated nonprofit associations, it became apparent that was kind of an untapped area where we could build around the concept of decentralized governance, find a home with some protections, and actually be able to meet compliance obligations in a way that was, attainable, which is nice. And so the DUNA was kind of an offshoot of that. The DUNA itself does not provide any protections at the baseline UNA. So Wyoming adopted the UNA in 1993. There's not any protections in the DUNA. There's not any extra privileges. It wasn't a land grab where it extended it to be specific to the blockchain for, in the case of the blockchain, things get treated better. It was simply longer because it provided a lot of clarity in how organizations could utilize on-chain governance to make that part of their governing principles in conjunction with an association agreement. And so it was a way of coordinating on-chain voting with existing rules in a way that would make the community always be the group that's empowered. And so you were talking to Will and Ian over at Syndicate. In the design of Syndicate, what those members definitely have control over is the amount of tokens that are in the treasury. So they can make award grants, they can have governance proposals, send outbound distributions of value, outbound dispositions of value out into the community for awards, to have app chain partnerships. They can utilize grants of awards to further the benefit of the protocol, drive adoption, drive usership. Now, the compromise in that is whenever you deal with taxation in the US and crypto generally, people do not love the tax reporting requirements. And when you have an outbound disposition from your treasury, you do have to put tax reporting requirements into place. So we have a system designed where we're going to be capturing the W8, W9 information to make sure that if the 1099 was issued or withholding needs to be done, that's part of the mechanism for how the treasury works in this case. Which is a compromise solution off of doing nothing, but having an easy in place compliant system that works for the outbound dispositions of the treasury puts projects that adopt this in a much more clear legal picture over what it is that they're doing, whether they are compliant, and it kind of encourages growth. It's not the anarchist, I'm not going to ever do tax reporting, but if what you're really focused on is this working within a system of laws, is it compliant, am I at risk being in this entity, it allows for a lot of exploration and growth and development because we're kind of doing the blocking and tackling. We're meeting the necessary compliance obligations in a way that's not particularly burdensome to the community, because it's really important to make the distinction. We do not need to know who the members of a DUNA are. The people who vote do not need to have a membership list. We do not need to know who they are. They're able to keep their anonymity. It's if you're on the recipient end of receiving value that you would need to know who that person is. And so participation in the community, not disclosed. You're able to have the true decentralized worldview of having your token participation. You can speak anonymously, you can act anonymously. But if you're going to be on the recipient end of funds from the treasury, that's where the reporting mechanisms go into.
So I love this, Josh, because you asked one question and he's answered 17 of the 20 questions that I have here in different ways. And so without, maybe I won't get into too many of the details there, because I think we've talked about this in a variety of ways, and like where the underlying issues with DAOs lie and the legal liabilities that emerged. We had Devin from Uniswap Foundation on yesterday talking about that as being a core blocker for many of the things they want to go do. I'm kind of thinking maybe taking it up a level. I'm assuming you are spending a lot of time with regulators, at various levels of the United States government right now, and I'm very curious what, maybe within this Trump administration, within this sort of new regulatory permissiveness that we're at least seeing signaled, where does this DUNA play? Are there some new superpowers that are going to be unlocked here that we're not fully grokking right now?
I think market structure, the Clarity Act, is the really big unlock. I think the DUNA is designed to work very well within market structure. And as far as who I talk to, as far as regulators, I think I would need to disclose a relationship that I have from starting in this space. Miles Jennings is the general counsel and head of policy at A16Z. Miles was the person who brought me into the crypto space. I had left my job at Ernst & Young a little before COVID. He hadn't even joined A16Z yet. He was still working at Latham as their developing technology partner. And he brought to me some of the initial specs for taxation concerns around these organizations. And so we started working together very closely 4 or 5 years ago, where we started writing a series of papers on domestic entity structure, what it was about the Cayman Foundation that made us uncomfortable. And to kind of put a highlight on that became a very popular structure, primarily because the US was such a hostile regulatory environment. And so there was a need. So there was a need to find solutions that could impact the fact that crypto was not welcome in the United States. I mean, not to put too fine of a point on it, that was the reality. And so taking away whether or not you can effectively transfer the assets the way that you can, that you move the US team, that you can kind of pick your entity structure independent of where your operations actually are and where work is being done, and leaving that aside, even if all of that worked perfectly, what the Cayman Foundation structure, what the foreign foundation structure that kind of adopted as standard for a lot of projects does, is it takes the treasury, it takes control of the treasury, it takes a lot of the governance decisions, and it puts them into a board of directors, 3, 5, 1 person in some situations, external to the organization. Now, they oftentimes do their absolute best to follow what the votes of the community are, but there's a true separation. And I'm not sure this is really very well understood broadly. What you're trying to do is put control of that asset, put control of any upgradable functionality of the smart contract in the hand of that foundation. So it's not the members who have it. Mm-hmm. Well, that's not a decentralized principle, right? So if we ask ourselves, is that what we're actually wanting? Is that what's good for DAOs, to be completely removed and hope that that foundation does what you would like it to do? That was always the problem with it. And so because of the regulatory environment and because of the need, that is why that evolved. What the DUNA represents is an opportunity for that treasury to actually be under governance, for the utilization of those upgrades to be through governance, for the governance token to actually work in the way it was intended to work. So from that standpoint, I can say it's a huge unlock because communities have that representative power that was so popular with individuals when DAOs first came around. And the reality of not living up to that expectation has killed a lot of the enthusiasm. So this is a reversion back to a basic principle. The token holders have the control. They own the treasury collectively. They decide what to do with it collectively. And so that's a huge power. Within the context of market structure, we also have the ability for, because the other negative side, and Miles hits this side a lot more, VCs, founders, they have to separate. It incentivizes them to separate from the project. The best thing you could do from a compliance standpoint was to have the founder walk away from the project. Well, what project in its earliest stages benefits from being deprived of the people who created it, who care about it the most, who know the most about it? And so in conjunction with Clarity and some of the Senate most recent drafts that have shown real improvement on this concept, it's the ability for the founders to stay involved. It's the ability for the investors to care, for people to participate. We've kind of broken up this Howey test of efforts of others, and we focused on what's really important. You need to build something before you can take value from it. That's the concept we're moving towards. That's a huge unlock because we now have the opportunity to publicly continue to contribute, to have idea formation, to have thought partners lead the way without being worried they're doing too much of the efforts for considerations of a security. And so if we can bring the treasuries back under the control of the US, the programmatic function, the upgradable function of the protocols back under the choice of the governance token holders, we've kind of consolidated what a DAO is intended to be back to basics. If that's done in conjunction with market structure, we have the ability to have people contribute their efforts in a public way that drives these projects forward. Collectively, that's a huge improvement. That's a huge unlock. And we get to start back to the path I think we all thought we were on 4 years ago of seeing what a truly empowered decentralized community can do.
So to me, one of the big open questions in the Market Structures Act, and I think Miles has talked about this, or at least A16Z and some of their broader writing, it's sort of been on where does decentralization live within the stack of a project, right? So is it purely on open source smart contracts? Is it validator sets, or is it token weighted voting? Do you have a sense of how likely something like a token governed by a DUNA, or the impacts that would have on the actual securities classification of these things? Like, is the DUNA playing a major role in sort of the pushing of these assets into more of the commodity classification than a security classification?
Well, so if you look at where the distinction kind of that flows through the market structure bills has been when decentralized is focused, and the DUNA was actually specifically mentioned within one of the recent drafts. Decentralized entities are excluded from a lot of the control tests because of their decentralized nature. Now, they have to meet ownership requirements, they need to meet operational requirements. But if you were to put this into a foundation, you could raise the question, does the existence of a foundation of that level of centralized control, is that going to be within the exclusions? Whereas when you have something like the DUNA, that decentralized entity that's been permissive through the laws, then we know that as long as that's functioning the way that it's intended, the way that it should, you can't just call something a DUNA, have it operate centralized and expect to get that result. But if you live up to the promise of what's being outlined here, and you actually have a decentralized community, then throughout those versions of the bills that are hopefully to be enacted, this type of decentralized relationship is the textbook definition of the exclusion mechanism for not being too centralized. Because the clarity bill from the House and the mindset around decentralization is when you have this decentralized entity, it represents different risks. What you're concerned about are control risks. You own too much of it. But if you have the limitations on what can be sold, what can be owned, and you have that kind of, for lack of a better word, clarity, and your organization can operate within those rules, then we're at a place where we actually have fit for purpose laws that incentivize and allow the activity that we're trying to do.
Yeah, I think this is a consistently under discussed point of the Clarity Act, really some of the regulations that are hopefully coming through. Obviously, we still don't know what that final bill will look like. We don't know how long it's going to take to enact. But to me, as somebody who's been fascinated, at least with like the open and permissiveness of crypto as kind of a core benefit, especially around early stage, founders, products, participation from retail users or community members. To me, this is the thing that has me most excited, and I think it have a fairly big impact on the space that we're building in. So, David, we got to leave it there, man. Really appreciate you jumping on, and clearly you have a wealth of knowledge in this. I mean, who better to go down this path with than somebody who participated in the creation of it. I know I've had a chance to chat in the past, so appreciate all the work that you guys have done here, and maybe we get you back on when we need to unpack some more of these nuanced details that Josh and I are not smart enough to fully grok ourselves.
Always happy to talk. Thank you for having me.
Thanks for coming on, man. Peace.
I guess.